morning, everyone. My name's Carrie Keller, and I'm a partner here at the firm's corporate and real estate departments. And this morning, I'm going to be speaking to you about practical things you can be doing now to prepare your business for sale in the COVID-19 environment. It's no secret. We all know COVID-19 caused a lot of disruption and uncertainty in the business and financial markets. And that initially, sort of resulted in a slowdown in M&A transactions, but we've seen the market pick back up, accelerate in some areas. Certainly buyers with access to capital aren't afraid of moving forward with acquisitions in this era, and particularly with respect to distressed companies, we see a lot of activity. And so you want to be mindful, though, that in addition to the usual issues that come up during the negotiation of a transaction, buyers are going to be focusing now on specific issues that have been caused by the COVID environment. So you have your normal issues that would come up in a transaction, but now that's sort of enhanced by some of these COVID issues. So, and as a seller, you have to be thinking that buyers are looking for deals always and might be seeking to sort of leverage the effects that COVID has to offer less than favorable deal terms or a lower purchase price or, things that wouldn't be advantageous to the seller. So you kind of want to be taking steps now to ensure not only a more streamlined deal, but to be in a better position to address the issues that buyers may attempt to raise and to also keep in the long view limiting your indemnity liability after the deal closes. So what can you be doing now? And I think first and probably the most important thing that you can be aware of is that you want to be preparing now for a buyer's enhanced due diligence. Due diligence in connection with M&A transactions will have an increased importance as a result of these business disruptions, financial impacts, and responses to the pandemic. So if you want to flip to the first slide. So sellers should be aware of the areas that potential buyers will focus on so that you can realistically evaluate the value of the transaction, work to hopefully address some of these issues before they're uncovered as part of the due diligence process or as the deal progresses, and be prepared to reach reasonable accommodations with the seller as a result of with the buyer as a result of any of these issues. So particular areas of importance that you want to be focusing on are your material contracts, your supply chain and sort of overall operations, your financial statements, tax issues, and employment law compliance. So on the operations side, you want to be looking at your material contracts, your supply chain, and your operations now. And with respect to your material contracts, look now, do an overview, assess whether or not there have been any material breaches of these contracts by either party to the contract. So not just if you yourself have breached, but if another party to the contract has breached those contracts. And if there has been a breach, are there any force majeure or other provisions in the contract that would excuse performance? I mean, these are things that your buyers are going to be looking at to determine, what are your major contracts? Are they in good standing? Have there been any breaches? And if there are breaches, be very clear. Identify what those breaches are, know what the consequences are of those breaches, and any rights and remedies that arise as a result of the breach. So be aware of things that you as the seller, liabilities that you as the seller might be exposed to for breaching a material contract. But if it's the other party that has breached the contract, be aware of what remedies you might be entitled to as a result of those breaches, because that'll come up as part of the negotiations, and you're going to want to allocate those rights and responsibilities between yourself and the buyer to make sure that the contract, that the asset purchase agreement or the stock purchase agreement adequately addresses those issues. Also, be aware of any issues that you've had with your supply chain. If you've faced issues or delays in obtaining inventory or raw materials, supplies, or other resources that are important to your business, you're going to need to be prepared to demonstrate how you've come up with adequate alternative sources of supply, and or if you haven't, what you've been doing instead, how your supply chain has been disrupted, and if those alternatives are more difficult or expensive to secure, what have you done in the long range to make sure that you can revert back to your regular supply chain? So just be aware of those issues and be prepared to discuss them with potential buyers so that they know that you have these, that you're thinking about these issues, that there's a remedy in place, because they're going to want to know, how these things can be addressed and how they can be handled post-closing. Buyers are also going to be looking at just globally the overall impact COVID has had on your operations. So we all know that certain industries like hospitality, travel have been disproportionately affected by responses to COVID. But there are other hidden vulnerabilities that your business may be confronting. If you have a major supplier or facilities or operations that are in a disproportionately affected region, or you have decreased customer demand, those may have had direct effects on your business, which was otherwise, maybe an essential business that was able to stay open or was relatively stable in terms of its operations as its employees transitioned to working from home. But be aware and be able to speak intelligently regarding how COVID has affected your operations, or if it hasn't affected your operations, how you were able to continue operations without any negative effects of COVID. Buyers are also going to be looking at, to the extent that you were able to resume operations, whether you violated any health or safety orders and you established adequate health and safety protocols for your employees returning to work, both in an appropriate time and in an appropriate manner. Buyers are not going to want to be exposed to liability, potential liability, if there were violations of stay-at-home orders, or you have, a group of employees who were causing issues because they felt it wasn't safe to return to work. So you need to be able to address those issues, speak on them intelligently, so that you can put your buyer at ease that those aren't areas of concern for your business. Another area that you want to put potential or particular emphasis on right now are financial statements and the solvency or insolvency of your business. Financial statements are always an area of special focus during due diligence, but in this climate, you can expect prospective buyers will be conducting comprehensive financial due diligence with an increased focus on determining whether or not the seller is solvent or approaching insolvency. So to the extent that you have interim financial statements or periodical financial statements, review those in detail with respect specifically to how any increased expenses or decreased revenue that are direct consequences of operating in the COVID-19 environment are, how those have affected your bottom line, and how you can discuss them with the buyer to address any questions or concerns that they may have. It's been my experience that, your financial statements are never perfect. Nobody's financial statements are perfect, but to the extent that you can have an open and honest conversation with the buyer about anomalies in your financial statements, or if you had a bad year, if you're able to speak intelligently, explain why that happened, buyers are understanding of that, and the more information that you're able to provide and the better you're able to speak on those issues, the less leverage the buyer is going to have to use poor financial performance to give you less than favorable deal terms. You also want to make sure that your financial statements have adequate reserves for any potential COVID-related liabilities to reflect to a potential buyer that you've considered those contingencies. So you may not have any of those issues, and if you don't, that's great. But if you have any potential liabilities, so for example, if you have breached a material contract and the other party to the contract isn't being particularly understanding about it, or you think that there's going to be a potential exposure for breach down the line, make sure that you have adequate reserves so that your buyer knows, hey, they're thinking about that, they're aware it's an issue, and that you've made adequate reserves to cover that liability. If you want to move to the next slide, please. Another area that's always an area of additional scrutiny is taxes. But in this environment, I think you can expect that there will be significant exposure and review of this particular area. The CARES Act created several new tax issues that impact not only the 2020 tax year, but other tax years, and which buyers and sellers are going to need to analyze to determine who gets the benefits and potential burdens of those tax law changes. So as a seller, you want to make sure that you understand what benefits you're entitled to and make sure that you get the benefits of all those tax law changes that are attributable to the time period that you own the company. So this is not intended to be a comprehensive review of all of the CARES Act tax law changes, but I just want to highlight a few that I thought might be common to most sellers, and those are net operating losses, deferred payroll taxes, and employee retention credits. So net operating losses that were incurred in 2018, 2019, and 2020 can now generally be carried back 5 years, and net operating losses can be carried forward and net operating losses that were carried forward to 2019 and 2020 are no longer subject to the 80% taxable income limitation. So look at your net operating losses to determine whether the treatment of those net operating losses and the carrybacks and carry forwards are properly allocated between you and the seller. I don't want a buyer to take advantage of a net operating loss carry forward or a carryback that you should have because you own the company during that time period. So you want to have a good understanding of what those net operating losses are and what tax years they can be taken in. Deferred payroll taxes, employers who delayed payment of their payroll taxes are permitted to pay 50% of that deferred amount by December 31st of 2021 and the remaining half by December 31st of 2022. If they aren't paid prior to closing, the deferred payroll amounts could potentially affect your working capital calculation and remain your responsibility, or your buyer may require that you pay those prior to closing or simultaneously with closing. So just know what those deferred amounts are, if any, and if your liquidity permits, consider paying those amounts prior to closing, or at least go into the deal with the expectation that your buyer may require you to do so prior to or simultaneously with closing, or escrow those amounts or something. It could affect, the amount of cash that you actually receive at closing. Employee retention credits, I just wanted to highlight this really quickly. Last time I checked, and I think it's still the case, PPP loan borrowers aren't eligible for this credit. So, and I'm assuming most, if not all, are PPP loan borrowers. So, but to the extent that you aren't, you may be entitled to employee retention credit. So be aware of what that credit would be and make sure that you are getting an allocation of that credit, or you're being able to take advantage of that credit, and the buyer isn't going to get a windfall for a tax period that you owned the company. Other area of concern and things to think about in review and audit right now are employment law issues and compliance. There were a ton of different sort of employment law reforms providing both temporary and permanent accommodations to employees, including extension of paid sick leave, temporary sick leave, and payments. So your buyers are going to be looking at very closely at whether or not you complied with those tax law changes and complied with HIPAA and privacy policies and safety and health and safety protocols and procedures, and that you took all the steps that you were supposed to take if there were any layoffs, mass furloughs. And so just now start looking at those things, make sure there aren't any issues. Probably most of you did everything perfectly and got good advice from your professional advisors, and it's not an area of concern, but just double check, because it will be something that these buyers will be looking at. Also, and this seems like a small, simple thing, but double check that all of your sort of corporate governance and regulatory filings are up to date. And I am talking at the most basic level. Make sure that all your DBAs were renewed correctly, your annual reports were filed, things of that nature. It's annual shareholder meetings and board meetings that may have been delayed or dealt with informally because of travel bans and social distancing might create a gap in your records, in your corporate records. And so you want to make sure that you have those covered before you enter into due diligence, because buyers will be looking at that. They will expect you to rectify those prior to closing. Same thing for your annual reports and normal filings. A lot of offices, Secretary of State's offices, were working remotely or at reduced staffing levels, and so there's delays and backlogs. And those are all little things that you can take care of now, so that during the due diligence process, during the negotiation, you aren't dealing with all these tiny little nitpicky things here and there. Just have all that taken care of. Make sure everything's addressed right now and everything's been filed and is in place. Move to the next slide, please. So another thing to be thinking about now is issues related to material adverse effects. So most M&A agreements contain some type of material adverse effect clause that's intended to address significant events that impacted your business. And these clauses can impact a transaction in two respects. First, they can limit your representations and warranties with respect to certain items, so that you can use them as part of the deal document, as part of your negotiation, to sort of limit the reps and warranties and things that you're saying about your business. But they can also give a buyer the ability to terminate the deal due to changes in your business. And standard material adverse effect clauses address both the duration of the impact and whether that impact was disproportionate to your particular business in relation to other businesses in the industry. So be thinking now about any thresholds or exclusions or things of that nature that could be applicable to your particular business or industry, so that you're better prepared to more effectively utilize and negotiate these provisions. And be prepared to talk to your attorney about what those specific things may be, because the attorney can negotiate the material adverse effect clause, but they won't know in most cases, won't know the practical realities of how your business may have been disproportionately affected. So, for example, if you are a business that was able to stay open, you were a construction business, so you were an essential business and you didn't ever necessarily have to shut down, but you were disproportionately impacted because your specialty in construction is something that it was, I don't know, let's say strip center construction or something of that nature. So maybe you had a slowdown because your customers pulled back on the project. And so you, even though you are a business that was an essential business and stayed open, you were disproportionately impacted because the nature of your customer base caused a slowdown. So be prepared to talk to your attorney about that, because these are things that you can use to negotiate a better deal for yourself or limit your liability moving forward. And finally, the last thing I want to talk about is PPP loan forgiveness. So if we can move to the next slide. The SBA released guidance in early October that affects M&A transactions involving sellers with PPP loans. And in general now, PPP lenders are required to obtain the SBA's prior consent to any change of ownership of the borrower that occurs within the first 12 months after the final disbursement of the PPP loan. So what is a change of ownership? The SBA considers a change of ownership to have occurred when at least one of the following has occurred. So either a sale or transfer of 20% of the equity ownership of a PPP borrower. So in addition to the M&A context, just a piece of advice, if you have a regular gifting program, or maybe you were going to allow a long-term employee to buy in or something of that nature, be aware if it was more than 20%, because that would be considered a change in ownership that could trigger this issue. So change in a sale or transfer of 20% or more of equity ownership, a sale of 50% or more of a borrower's assets in their fair market value, or a merger into another entity. And for purposes of satisfying that 20% ownership threshold or the 50% asset threshold, all transfers since the PPP loan approval must be aggregated. So if you were selling assets prior to this final transfer, this final transfer, or if you were making transfers of stock during the year, be aware that they're going to look at, in the aggregate, all of those transfers for determining whether or not there was a change in ownership. So to get the SBA's consent to the PPP loan or to the change in ownership, you're going to have to provide the PPP lender with written notice of your contemplated change of ownership, along with copies of the proposed agreements or the other documents that would effectuate the change of ownership. And the SBA has 60 days to review and assess requests for consent. So 60 days is a long time in the M&A world, and I think you want to be aware that you're going to be having to ask for consent to this change in ownership pretty quickly into the deal, and confronting this issue right away in order to make sure that it doesn't hold you up on the back end. So when do you not need consent? You can go to the next slide. You wouldn't need consent if you've either paid it in full, or the PPP loan has been forgiven and the SBA has remitted the funds to the PPP lender, or you've paid, if there was only a portion of it that was forgiven, you've paid the balance. So if you can do that now, if you've already begun the forgiveness program, or if you think you're going to contemplate a sale, start asking for forgiveness now so that you aren't held up on the back end by trying to get this consent. The only other way to move forward with the deal without that consent is to request consent to the transfer, but also simultaneously fund an escrow account with your PPP lender in the amount of the PPP loan balance. So if you don't want to get held up on the deal and you haven't paid it off or you haven't gotten forgiveness, the only other way to address it is to essentially request that consent but simultaneously fund an escrow with the full amount of the PPP loan, which most borrowers aren't going to want to do. The only other thing to be aware of is that in an asset sale situation, the guidance says that the SBA is going to require that buyer to assume all of the PPP borrower's obligations under the loan, and that's going to include not only providing them with a copy of the asset sale, but also actual documentation of a separate assumption agreement, or the documentation has to include the buyer's assumption of your PPP loan. So I think just the takeaway from that is really move forward with your forgiveness application if you haven't already, if you think you are going to sell your business, because otherwise I think it gets just a little bit too complicated, or you're going to have to outlay a lot of funds that you don't necessarily want to outlay and have them temporarily held until you get that forgiveness. So with that, I'm going to turn things over to Bill so that he can talk about distressed sales.
All right. Thank you very much, Carrie. I appreciate it. As Carrie said, I'm going to be talking about distressed asset sales in bankruptcy. Obviously, this is just another mechanism through which you can use to sell either your entire business or substantially all of your assets through the bankruptcy. The first thing I want to kind of start out by saying is that almost everything that Carrie discussed in her presentation is equally applicable in this context. All the enhanced due diligence, all the marketing, all the things that she discussed will need to be undertaken in a distressed situation as well. But I'm going to be talking about a very specific procedure and process that you can use through the bankruptcy process to assist in that sale process. And the sale process through bankruptcy has been used for decades now, but it's becoming even more popular these days, especially with the state of the economy through the COVID pandemic. And I see that some states are now going back to almost full lockdown, stay-at-home orders. So I'm envisioning a number of bankruptcies occurring, if not this year, maybe into first and second quarter of next year, as we probably stay locked down until the vaccine comes around. But, just to give you an idea, I've been involved in 6 of these in the past 6 months, and that's a pretty good clip for me. So this is definitely something that's here. It's here to stay, and especially given where we are with the COVID pandemic, I think we're going to be seeing it for a while. So as you can see in that first slide, the Bankruptcy Code authorizes the sale of assets, either substantially all the assets or some of the assets, through either a plan or through Section 363 of the Bankruptcy Code. We won't talk about the plan process much because that's the subject of an entire semester or two of law school courses. It's very long, complex. The plan process can be very, very expensive, so it doesn't really fit the needs of most businesses attempting to sell their assets. On the other hand, what's called a Section 363 sale, and it's called a Section 363 sale because there's a portion of the bankruptcy code, Section 363, of course, which specifically authorizes this type of business sale or asset sale. And it's really used because it is quicker and more cost effective. And again, as I mentioned, I've seen it used 6 times in the past 6 months in my own practice, so you can imagine what's going on around the nation with these sales. One of the key hallmarks of a 363 sale is that a seller is able to offer its assets free and clear of liens, claims, and encumbrances. That's great for a seller, obviously, because it allows for a high purchase price. It allows a buyer to know that it is taking those assets without all of the hair, quote unquote, that comes with a lot of deals. Just so we're clear, the assets are sold free and clear of the liens, claims, and encumbrances, but all of those attach to the proceeds of the sale. So you're not just extinguishing those guarantees or the security interests or whatever they are. They attach to the proceeds, and those will all be dealt with through the bankruptcy case. But in terms of a buyer, the buyer is able to take those assets free and clear. One of the major drawbacks of the sale, however, is that unlike you heard Carrie talking about in the kind of out-of-court context where you can select a buyer and negotiate with that specific buyer and everything is kind of done very privately and exclusively with that one buyer, that's generally not the case in a 363 sale. A 363 sale involves an auction, which we'll talk about in a little bit, but you do have a loss of control as the seller as to whom you are selling the goods. You can, of course, direct them, which we'll talk about in a second, and kind of lead who may be the winner of those assets. But in general, it is always subject to higher and better offers by other potential bidders. If you want to go to the next slide. Thank you. So this slide is just kind of a general overview of the process. We'll get into the more specifics in the upcoming slides. But again, it starts with pre-bankruptcy marketing and pre-bankruptcy due diligence. As Carrie discussed, the enhanced due diligence is incredibly important, not only outside of court, but especially in this 363 process. One of the reasons is that most of the time the buyer is taking as is. So you're not going to have the warranties and representations that you're going to have outside the bankruptcy context because you may very well not have a debtor/seller around to honor its indemnity obligations or cure issues or any of the other issues that you might be able to rely upon as a buyer of these goods outside the bankruptcy process. So marketing and due diligence beforehand is key and critical, especially for a seller wanting to get the best price for their goods. What happens in the middle of the marketing and due diligence process is you as a seller may come across a particular buyer that you think is best suited. Maybe you know the business, you know your assets or your business would fit in well with what they do. You know they are financial capable. You know they are able to close the deal, etc. They've offered an acceptable price. And in that event, in the the sale, Section 363 sale process, you can designate them what's called a stalking horse bidder. And we'll talk about what that exactly is in a little bit. But in general, it means that someone has come in and made you an offer that you'd like to move forward with. And we'll talk about how that works out in a second. But once you've kind of located that stalking horse bidder, you entered into an asset purchase agreement. And we've talked about that a little bit with Carrie earlier, but that's really the agreement that sets out the price and the kind of structure of how the deal is going to go down. And that's the same kind of in court as it would be out of court. This is where the kind of process changes a little more for the in-court procedure. At that point in time, you are going to need, as a distressed business, to actually file a bankruptcy case. Now, again, we don't have time here to go through all of the ins and outs of, chapter filing and how it works and what you need to do to file a bankruptcy case. But I just want to make sure that we mention, we can't forget that in the middle of this process, we are trying to sell the assets, but we still need to do it with the bankruptcy code in mind and the processes and procedures of the bankruptcy code taken into account. So as part of that, you want to file a bankruptcy case, and then you'll need to file a motion with the court for authority to enter into the asset purchase agreement and proceed with the sale. And that's, again, another big difference between what Carrie was talking about and the process in the 363 sale. Almost everything a debtor needs to do in a bankruptcy case needs approval and authority from the bankruptcy court. So this is no different. If you are planning on selling your business or selling a substantial portion of your assets, you will need to get court authority to do so. You will need court authority to enter into the asset purchase agreement, and you'll also need to get court authority to enter to the next bullet point you see there, which is the bid procedures. Bid procedures we'll talk about a little more in detail coming up, but again, it's just kind of the rules and regulations that you will be announcing to the world in terms of how they can potentially acquire your assets. Again, a little bit different than you see outside the bankruptcy context, where you may be only working with one potential buyer. As I mentioned, in the bankruptcy process, you have to open it up to multiple buyers, and those rules and regulations and processes and procedures will all be dictated by the bid procedures. Then you'll go into an auction process, which we'll talk about later, and that all results in an actual sale order, which is obviously a most important part of the process, which we can talk about a little bit later as well. Let's turn the slide and we'll talk about the stalking horse a little bit. So stalking horse bidder, for anyone who's unfamiliar with the term, if you are unfamiliar with the term, you'll probably hear it more and more over the next year. But a stalking horse bidder is basically a bidder that sets the floor for the sale price of the asset. So as I mentioned earlier, if you've done your marketing and you've done your due diligence with somebody, you found a party that you are interested in pursuing a transaction with, they've maybe made an offer, and you are accepting of that offer, you think it's a valuable or a fair price for the assets, you can designate them your stalking horse bidder. And what that means is basically at the end of this procedure, if you've got a stalking horse lined up, you know that you are going to get a certain amount of money for your assets. It could be higher, but you know even if nobody else shows up at an auction, if nobody else wants the assets, you know that stalking horse bidder is going to show up and bid the amount that they've promised. The stalking horse bidder, as I mentioned, is given early access to the assets for due diligence purposes. Again, that just goes back to Carrie talking about the enhanced due diligence. A stalking horse bidder is often at a little bit of an advantage over other bidders in the 363 process because they've had early access to the assets. They've probably had the ability to make sure their financing is in place. They've investigated all the things that really need to be investigated before you even get to the bankruptcy case. The other thing that's important for a stalking horse bidder is that they really are the first potential purchaser to be able to negotiate an APA. Again, that's the asset purchase agreement, and set the structure for the deal. And this is important because that stalking horse bidder has a leg up on everybody else. Any other future bidders really do need to kind of structure their deal and their offer around the APA that was negotiated by that original stalking horse. And obviously that's because we want to make sure that our offers are apples to apples offers, and that we as a seller can really choose the best option from those menu of bidders. The stalking horse bid, in exchange for taking this early risk and diving in and doing all the due diligence, et cetera, can be compensated for setting the floor and guaranteeing the fact that we are going to end this process with an acceptable purchase price for those goods. We'll talk a little bit more about what those compensation mechanisms are in a little bit. But the last thing that I really want to talk about stalking horse bidder is it must put skin in the game. So this is important because, again, what we're talking about here is really a bidder that has come in, has put earnest money down, they've signed a letter of intent, maybe they've even already executed a fully enforceable asset purchase agreement, but they are ready to close, right? They are putting their money on the table. They're ready to go forward, but they also realize that it will be subject to higher and better bids at an auction, which we'll talk about in a little bit. But they really do have to have skin in the game. It can't be, kind of a fly-by-night, I promise that I'm going to do this when we get there. They need to be locked in and ready to go. Let's change the slide. Okay, so then once you have a stalking horse bidder lined up, chances are if you haven't filed the bankruptcy case already, you'll want to do so once you've got that stalking horse bidder lined up. Once you've got your asset purchase agreement signed and executed with the letter of intent and the earnest money down, as I mentioned, you want to file the bankruptcy case and you want to file a motion for authority to enter into that asset purchase agreement and sell your asset. In addition to that, however, something that's a little bit different in the 363 sale process as opposed to the out-of-court process, which Carrie discussed a little, is this slide here, which is the bid procedures motion. And basically the bid procedures motion, again, is something that needs to be approved by the bankruptcy court, authorized, because we are still under the umbrella of the bankruptcy process. But it basically announces to the world the auction process, the 363 process by which other parties can come in and bid on this business or these assets. You can see right from the first bullet point there, it designates the stalking horse bidder. So it will announce to the world, we have entered into an agreement with party A. They have agreed to pay X price. We're going to be holding an auction at a certain point in time in the future, and everyone is willing to or able to show up and bid under certain circumstances. So you'll also see there that it provides bid protection for the stalking horse. As we talked about, bid protection can come in multiple forms. It's highly negotiated usually, but it exists to, again, compensate that stalking horse bidder for coming in and setting the floor of the sale price. So oftentimes you'll see what's called a breakup fee and expense reimbursement to the stalking horse. Basically what that means is a stalking horse bidder comes in and makes an offer, let's just say, for example, $10 million for the assets, and they will say, I want a $500,000 breakup fee in case I get outbid at any auction. And that breakup fee is a standard term. The percentage of it and the amount of it are highly negotiable, but there are plenty of cases decided in the bankruptcy courts across the land which kind of lay out what that percentage can and can't be. But in general, it's highly negotiated, and it compensates the stalking horse bidder for coming in, taking all the risk, doing all the legwork, signing on the dotted line, so to speak, putting up their earnest money, and then having to take the risk of getting outbid at an auction. So that is something that's very, very common, and I can't imagine many stalking horse bidders coming into this process without requesting a breakup fee or expense reimbursements. It also plays into bid increments. And what I mean by that is, as I mentioned, if you've got a stalking horse bid coming in at $10 million, they've asked for a $500,000 breakup fee, the next highest bid may have to be $10,600,000. And that's to compensate, again, for the payment of the breakup fee and an increase over their offer. So, again, you have a little bit of an advantage to be the stalking horse bidder because you've gone from, a $10 million offer to the next highest bidder already has to come in at $10,600,000. And I'm just using these numbers. Obviously, the numbers can change, but hopefully you get the point, is that there's a little bit of protection there for the stalking horse bidder. The next thing that the bid procedures motion will do, it'll set financial and other requirements to be a qualified bidder. So this comes into play when you've got bidders who want to come in and kick the tires, but maybe we all know that they're just snooping around. They don't have the financial wherewithal to complete this transaction. They don't have the operational capabilities to complete the transaction. They may not be a qualified bidder. And through a bid procedures motion, you can limit who and who cannot come into these procedures. Now, of course, you need to be careful. You can't make them so restrictive to chill the bidding on the assets. But at the same time, if you've got, mom and pop store B coming in to try and purchase a $100 million business, they may not be a qualified bidder and may not be able to participate in these bid procedures. So those are all things that will be laid out in the bid procedures motion. Additionally, it sets the process timeframes, for the end of due diligence, bid deadlines, and an auction date. So again, what we're talking about here is a process run through a court system, and a court system agreeing and authorizing a process by which you have a certain date when all bids need to be in. That usually obviously occurs after you've given parties to do some due diligence, but we're talking about a bankruptcy case here. So those due diligence timeframes and bid deadlines are probably going to be shortened. I can't imagine you're going to have a 6-month due diligence period here. I've seen due diligence periods as short as 30 days. It's a rushed process. And again, you see the kind of benefits of being a stalking horse bidder because they've already had the time to do a lot of that due diligence. But regardless, in your bid procedures motion, you can lay out deadlines and timeframes. And at the end of that, you will have an auction and a sale hearing, which will result in the federal bankruptcy court actually approving the sale, which we'll talk about here a little bit as well. So let's move to the auction, the next slide. Okay, as I mentioned, you will have an auction, assuming you've got a number of bids from qualified bidders. The auction is usually held in person. It's usually attended by the debtor and qualified bidders. And I say that with some hesitation because regardless of what I just said about the bid procedures and requiring certain people to, be qualified and have those kind of requirements in there, a bankruptcy court is, at the end of the day, a court of equity, and it is concerned with obtaining the highest bid for those assets. So while it likes to do such within the confines of the motions that have been approved and the bid procedures orders that have been entered, if you have a party who comes to an auction and they are not, previously a qualified bidder, but let's just say it's, Amazon, who comes into the auction and they're willing to bid 3 times the amount of any bid you've received to date, the chances of Amazon being excluded from participation in that auction are probably limited, right? Again, it's a process of wanting to get the highest and best offers for these assets while at the same time doing so with some structure. So just keep that in mind. It doesn't necessarily mean that other parties can't come in and bid, especially if we are aware that they have the financial wherewithal to actually consummate the transaction. Should be transcribed. Again, this is a process that might be reviewed later on, so a court reporter is always a good idea. It is not like an open outcry auction that you hear or see on TV, or an art auction where the barker calls out a number of different bids and prices very, very quickly. This is much more calm type of auction. At the very beginning, the debtor will usually announce that he has a stalking horse bid, the price of that bid, pursuant to the bid procedures, the next highest bid has to be at X, and then just open up the floor to all the bidders in attendance and allow the price to be bid up. At the end of the day, the debtor, usually in conjunction with its professionals, will select, and I'll mention there, and possibly in conjunction with its secured creditors as well, because usually secured creditors play a large role in these matters. We haven't talked about that too much, but in general, a debtor's secured creditors are going to have a large say in this process because they are going to get substantially all of the, I shouldn't say substantially all, in some situations, substantially all of the proceeds of these sales. So the debtor then selects the highest and best bid to be the winning, quote-unquote, buyer at the auction. All right, let's turn the page. All right, so once we have determined that we have a winning bidder at the auction, as I mentioned previously, pursuant to the bid procedures order, there has already been, or should have already been, an actual hearing set up for the approval of that sale. And that hearing will result in the sale order. And this is really the end-all, be-all of the Section 363 process, because this is what sets the Section 363 sale apart from a sale outside of bankruptcy. And that is a federal court order authorizing the sale, and guaranteeing the transfer of the asset. And that's something that you're not going to find in any other process. And especially in a distressed situation, that order really carries a lot of weight both to the buyer in terms of being able to get the highest possible price it can, the seller able to get the highest possible price it can, and the buyer who's able to wave around a federal court order to anybody who might be challenging claims against the assets or successor liability claims or anything like that. So that's why you see at the beginning of every single one of these bullet points, I have finding by bankruptcy court. And that's repeated on there. Obviously, it doesn't need to be, but it's repeated on there for emphasis. That's how important this is. And let's talk about some of the things that would be in the sale order. And I'll mention while we're talking about the sale order that the sale order is another one of the most highly negotiated parts of this process. The secured creditor, the debtor, the buyer, everybody wants to make sure they have the representations and the findings in that order that provided some comfort moving forward. So it's another, truly, truly important part of this process. So the first thing you see, again, is a finding by the bankruptcy court the assets are sold, quote, free and clear of liens, claims, and encumbrances. As we talked about, that's one of the biggest deals of the Section 363 sale, the fact that the seller can sell these things and get a higher price because the buyer knows it's taking them free and clear of all of the hair that might otherwise be on the assets. Second one there, you see a buyer can assume executory contracts and unexpired leases. So you heard Carrie talk a little bit about kind of the contracts and leases and how that need to be reviewed in the context of due diligence. And that's equally applicable here. As I mentioned, there's another provision of the bankruptcy code which allows a debtor to assume or reject certain contracts. So in the 363 process, the buyer and seller can work together to decide which leases, which contracts should be assumed, which should be rejected, and really narrow down, trim down, and fine-tune what the buyer does and does not want. Again, something that sometimes is not possible outside the bankruptcy context. Next one, truly important, finding by the bankruptcy court that purchase price was fair and reasonable. Again, you've got a buyer who comes in here, pays maybe a little bit of a premium to get this court order, and he's got a finding by a federal court that this purchase price was fair and reasonable. Finding the buyer is, in fact, a good faith purchaser. Again, should someone come in and try and contest the auction, again, the buyer has a document that they can wave around and say, nope, I've got a federal court finding that I am a good faith purchaser. The benefit to the seller, of course, is that is worth a premium. You can require a little bit more out of a buyer to be able to have that comfort. Next thing, finding by the bankruptcy court approving distributions. So we haven't talked much about what happens after the sale of the assets, but the sale proceeds will come into the bankruptcy court and be distributed. So depending on, priority positions, who's secured, who's unsecured, the court will make an order determining where that money goes. And it's not like an outside of the court process where it goes randomly and you might have people come in and question where it went and how it went and so on and so forth. This is another thing that could be in a court order directing those proceeds to be distributed. And the last thing is the finding by the bankruptcy court that the order is final and unappealable. So again, outside the bankruptcy context, you might have parties that are unaware of what's going on. You might have parties that want to contest it. In the bankruptcy context, you have given notice. You have given everyone a right to appear and contest the process or participate in the process. And at the end of that process, a buyer and seller are able to say, okay, this is the order. It's final. It's unappealable, and everybody's moving forward. And that's, again, something that a seller can charge a premium for because it really does give the buyer some comfort going forward that it is removed from any kind of path of litigation in regard to the purchase of the assets. Let's go to the last slide. All right. So again, this is just our kind of main takeaways that I kind of want to go over. The so-called 363 sale is an excellent option for selling a distressed business or its assets. It's quick, it's relatively inexpensive, and you walk away with a great order at the end. As I said right there, use quicker and less expensive in a sale through the bankruptcy plan process. The competitive process often drives up the sales price. So that's exactly right. You've got an auction. You've got different people that come in and bid on it. As we talked about, you've got the winning bidder taking free and clear, which increases the sale price. You've got the winning bidder coming in and can take as a good faith purchaser, which should also increase their willingness to pay a little more. The federal court order provides finality and enforceability, which we talked about. I don't have it on the slide there, but and security, right? You've got a seller who walks away with a federal court order that they can waive in potential creditors' faces. The downside, of course, is the loss of control over who buys the assets. Once you kind of put it in play, the business or the assets are in play, and if you've got somebody wanting to come in and bid on that, chances are they're going to be allowed to come in and bid on that. And the last kind of downside is absolute complete transparency. Sometimes you've got some issues in the business that you don't want aired in public, and those types of issues are not they don't work well with the bankruptcy process. Bankruptcy process kind of works well with full disclosure and trial in the sunshine, so to speak. And the sale process through 363 is no different. It requires absolute complete transparency or it won't work. But with that, I think that's all that I have to say. I'm happy to answer any questions if anybody has some, but that's all that I have. All right, I'm not seeing any questions come in yet, but I'll give it a couple seconds. Carrie, do you have anything else that you need to add in?
No, I don't think so.
Emily, is there anything else you need to add in? All right, I'll give it a couple more seconds for questions. Nope, I don't see any other questions coming in. So again, you have both Carrie and my phone number and email. If there are any questions that come up, if you have questions about the slides after you get them, hopefully later today or in the next 24 hours, feel free to reach out. We're happy to help. I'm going to thank Emily and our marketing staff for helping get this together. I'll, of course, thank my co-presenter, Carrie, for bringing this possible presentation to my attention. Happy to participate, and thanks for everyone for taking the time out of their morning to participate and listen to our presentation. With that, I'll wrap it up. Thank you very much, everyone.